The events of January 6th are always framed as an unconscionable attack on our democracy. It should be our constitutional republic, but they don't like that term because it reminds us that our first value is the protection of the rights of the individual, not simple majority rule. So it's an attack on our democracy instead, but I digress. The point is, January 6th is always presented as the day that our norms and our system and our rule of law nearly died. And sure, crimes were committed that day, and those who committed those crimes should be held accountable, and they are. I don't know anybody who would sincerely argue that accountability is lacking. The investigation and the prosecutions are the largest ever undertaken by the Justice Department. It's the ongoing focus of a forever congressional investigation. If anything, there's an overabundance of accountability forced where it doesn't necessarily apply and encroaches on the abusive. And that's the thing. Accountability and abuse are next door neighbors. The only thing that separates them is a commitment to that first principle that we started with, the protection and the preservation of the rights of the individual, including, very importantly, the rights of the accused. For all the talk of the norms of our system and the rule of law, apparently we care a lot less about those norms and the rule of law than we do punishing our political opponents. We don't care if those rights get undermined if it means we get our enemies. In fact, we might even prefer it. We have seen January 6th used as the premise to undermine the constitutional right against self-incrimination. We've seen January 6th used as the premise to redefine the term incitement away from the Supreme Court's narrowly constrained First Amendment definition into just a generic criminal accusation to throw at our political opponents. And of course, we have seen January 6th used as the premise to challenge and erode the constitutional rights to due process and a speedy trial as well. The Justice Department is handling many January 6th cases at a snail's pace, testing the patience of federal judges in addition to, obviously, the accused. The DOJ and the New York Times cite the volume of the evidence to handle in these cases. You decide if maybe there's another motive at play, but as though your constitutional rights are subject to the prosecutor's ability to handle the workload of taking them anyway. Last year, when one prosecutor tried to justify the slow pace by saying that January 6th is so uniquely challenging because of the amount of discovery material that's an important part of the legal process, the judge responded, yeah, freedom is also important. Now, I don't have to deny the seriousness of assault, the most serious charge from January 6th, outside of this sedition charge they've concocted more than a year later, to think that all of the erosion of these, not just norms, but constitutional foundations of our legal system and our country is just a little more serious. Crimes matter, but how we handle them matters at least as much. The word justice in justice system is supposed to mean something. If we don't uphold our commitment to just process, we aren't achieving it. We're just stacking new crimes on top of the old ones. But these betrayals of our values have been happening in this context for well over a year now. So what makes today's story about it new? Well, it's getting so egregious that even prosecutors themselves are now admitting to botching the case in violation of the law and the Constitution as a part of their legal strategy to try to start over and take another crack at it. This is the case of Lucas Denny, a Texas man formerly accused by federal prosecutors in mid-December of multiple January 6th felonies related to assault on Capitol Police. Prosecutors allege he used some sort of tube or pipe to swing at officers, among other aggressions. Prosecutors are calling his weapon a metal pipe or pole. His defense team says it was plastic PVC, but that's really beside the point of where this case stands now. So for the sake of understanding, let's just assume that the legitimate case exists, at least to bring those charges. Denny was arrested in Texas on December 13th. He appeared before a federal magistrate judge in Del Rio on December 14th and 17th, where he was denied bond and ordered to be transferred to Washington to face charges. He then disappeared in the court system, according to reporting, for about a month and a half, before records show he arrived at a federal holding jail on January 31st. Another month later, on February 25th, he was scheduled for a court date 2 weeks later. Earlier this month, on March 2nd, Denny's lawyers filed for his release, citing the prosecution's failure to obtain an indictment. And then prosecutors apparently remembered, oh yeah, that. And then on the 7th, brought a grand jury indictment for one count of assault on a police officer. But there are a lot of problems with that process, not just technicalities of court procedure. That is a violation of constitutional requirements. The indictment isn't just some formality. It's a Fifth Amendment right of the accused. And perhaps you say, yeah, well, they did that. They went and got that indictment. So what's the problem? The problem is the accused also enjoys a Sixth Amendment right to a speedy trial. Prosecutors failed to bring that indictment until nearly 3 months after Denny's arrest. Okay, so it was slow, but how speedy is speedy, really? And how slow is too slow? Well, we have federal law to define that. Under the Speedy Trial Act, which gives definition to your Sixth Amendment rights, an indictment must be filed within 30 days of arrest. That's not a suggestion or a guideline. That is a requirement of federal law based on constitutional mandate. Okay, so the law wasn't followed, the Constitution wasn't followed. This should be an easy case for a judge to handle. Case dismissed then, right? If only things were so simple. Of course not. The complication and the mental gymnastics have only just begun. Because of prosecutorial misconduct, this case has effectively been inverted. The prosecution is the defense, and the defense is the prosecution. The defense has agreed to a single charge, and the prosecution is saying, oh, no, please, judge, because of our prosecutorial error, this case must be dismissed. And I know, make it make sense. Well, here's how, or at least here's how they're trying to. The defense team just wants this case to be over, and they fear if they let it linger, well, that'll just be more time for prosecutors to remember they actually planned to tack on several more charges than just the one. So that's why the defense is willing to forgive the misconduct in the delay of the charge just to settle the matter. And the prosecution does want those additional charges. They don't want to get Denny on just one. They want him, just like all January 6th defendants, to be treated as harshly as possible, which is why they're arguing for dismissal of the case without prejudice, as in dismissal so the case can be brought again. So the process can just be restarted, because nothing says speedy trial like a clock reset button whenever the prosecution wants it. And it would seem like the Constitution and the law compel the judge to do the opposite, to dismiss this case for prosecutorial misconduct, close the book on it, and call it a day. And that could still happen, but it's nothing close to a certainty. On Monday, the judge handling the case would not dismiss it and wouldn't accept Denny's guilty plea on the single charge either, saying these developments are so unusual, he needs more time to examine the case law to rule properly. And so another hearing has been set for Thursday. All indications are Denny still plans to offer a guilty plea on that single count as a way to end all of this nonsense. And a closer look at the prosecution's argument reveals exactly what we opened with: a fixation on January 6th as the worst thing that's ever happened in the history of the country, while treating their own trampling of the Constitution and federal law as trivial. In their court filing Monday, prosecutors admit straight up, yes, we violated the Speedy Trial Act and by extension the Sixth Amendment, but come on, guys, we did it by accident. It was just an isolated incident that resulted from a number of complicated factors. Interesting that same defense of isolated incident doesn't extend to Denny, who has no prior criminal record himself. But yes, prosecutors like Denny acknowledge breaking the law. They just say the proper remedy is a dismissal without prejudice, meaning they could bring the case again, and not a dismissal with prejudice, which would close the case based on criteria established by prior case law. First, the seriousness of the offense. You can't just let such an egregious offender like this go, prosecutors say. Because after all, Denny is part of a crime unparalleled in American history, a grave threat to our democratic norms, unlike our own admitted violation of constitutional norms. But Denny committed the most serious crime charged outside of one sedition case that day: assault. Well, if a pipe swing is among the most serious charges of the day, the attack doesn't actually defy comparison to other crimes, as prosecutors allege. It's still a crime, yes, but it's the sort of crime that happens in every state every day in this country. And if it was one of the most serious crimes of that day, number one, why did it take you so long to charge it? And number two, how did you forget about it after the arrest? It was one of the most serious crimes in American history, but dang it, just kind of slipped our minds. You're bad at your job. And that slippery mind is their second argument. Actually, come on, we didn't have any bad faith or a pattern of neglect or something more than an unwitting and isolated violation. We're doing our best, and look, we're complying with other parts of the Speedy Trial Act, like making sure we follow the law's time allowances now that the indictment has been filed. As though Denny can argue, look, I didn't violate any federal murder laws as a defense for his alleged wrongdoing. If that would be a preposterous defense for him, it's just as preposterous for prosecutors. Lastly, and most infuriatingly, the government dismisses its own misconduct as trivial and unimportant. Per the prior case law, the impact of re-prosecution must be considered by the judge in this case, because without constraint, allowing a government do-over means prosecution can just happen again and again and again, no matter their mistakes, until they get it right. In other words, it presents a potential double jeopardy situation too. Yet another constitutional violation, facing trial for the same crime multiple times until prosecutors get what they want. But that's not how it works. They get one shot, not as many as they want or as many as they need to learn how to do their jobs correctly. Well, yeah, but this is all just a big mistake and a big misunderstanding, prosecutors say, as though if they mistakenly fail to persuade the jury, they should get another chance too. No, you don't. And again, notice, when Denny messes up, well, that's a crime on a scale unseen in our country's history. But when prosecutors actually trash our country's history, well, whoopsie, they'll do better next time. But if there is any encouragement, it's that judges are seeing through it. The judge currently handling Denny's case says he has serious concerns about how Denny's rights have been handled or not handled. He says things have not been handled the way they should have been, and Denny has been incarcerated longer than he should have been. The magistrate judge who handled the initial hearings declared himself very upset, asking what the hell is going on, saying he sees a person's rights that have been trampled. If there are no consequences for the government's mishandling of this case, he says, we will just be doomed to repeat the same failures, which is why whoopsie cannot be a justification for the blatant violation of our Constitution and the law that gives definition to it. If whoopsie gets us out of constitutional fidelity and compliance, we don't have a constitution. We will just have prosecutors who railroad you to their liking, as long as they say whoopsie when they do. And whatever you think of assault, and yes, I do think assault is a serious crime that should be prosecuted seriously, but whatever injustice exists in one guy getting away with it is completely insignificant compared to the injustice of trashing a system of prosecutorial constraint in favor of prosecutorial free reign. If there are no limitations to what these people can do to you with the full force of the federal government, we will all be assaulted much worse. And if you doubt that, consider which assault you'd prefer to experience: the smack of a PVC pipe or a federal prosecutor who can disappear you with a shrug. We should all choose wisely while there's still a choice to make. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.